Meanwhile, a row of over free speech and professional rights has now rocked Hyderabad's Nalsar University of Law, drawing in the Bar Council of India and even the Chief Justice. The trigger was when around 70 graduating students submitted a representation on the 23rd of July objecting to the reported invitation to CJI Surya Kant as chief guest at their convocation ceremony. Their objection was linked to remarks that the CJI had made during a Supreme Court hearing on the alleged police action against protesters at the 20th July demonstration at Delhi's Jantar Mantar. The Bar Council of India, which is headed by Chairman Manan Kumar Mishra, responded by directing all state bar councils not to enroll any Nalsar student from the 2026 batch, pending an inquiry into who organized the campaign against the CJI. The move triggered widespread backlash from the legal fraternity. Within hours, Mishra softened his stance. He said that the BCI was satisfied that the 2026 batch had no role in any disturbance or movement. Meanwhile, CJI Surya Kant himself weighed in. He called the BCI's original action absolutely uncalled for and asserted that students have the right to protest. The Supreme Court has sought a response from the BCI on the circular and directed no punitive action be taken against any Nalsar student or faculty member. The episode, of course, has reopened a larger debate on whether law universities remain spaces for dissent and whether a regulatory body like the BCI can penalize an entire graduating batch over a campus protest. Joining me on the broadcast is Dr. Swati Jindal Garg, advocate of the Supreme Court. We also have with us Advocate Sanjay Bansal, former Secretary of the Supreme Court Bar Association, Justice A.N. Mittal, former Judge of Allahabad High Court, and Ruchit Asha Kamal, social justice activist, with us on the broadcast as well. Let me begin this with Advocate Sanjay Bansal, who's been Secretary of the Supreme Court Bar Association. Advocate Bansal, it is another unnecessary controversy in India, what has happened at Nalsar, and then of course the aftermath of it. But I want to understand from you, sir, do you feel that it was a knee-jerk reaction by the Bar Council of India when there is by law, by the constitution, a right to protest? Why is it that the Bar Council, in your assessment, felt the need to interject in this matter? If there are a bunch of students that are dissenting on a campus and they don't want a specific entity to come and speak at their convocation for whatever reason, the CJI today has to point out himself that it's a matter between me and the students. Why are you coming in and why are you passing a circular? I want to understand from you, Advocate Bansal, A, was this a knee-jerk reaction? And secondly, sir, what is motivating bodies like the Bar Council of India to insert themselves in these matters in a way that, as lawyers, I would assume they would know there would be backlash against such orders?
Actually, this particular issue has so many facets that the independence and the freedom of speech is one of them. That too of the prospective lawyers who are going to, champion the cause of the citizens of this country before the court of law in protection of the law, being the law officers of the court. This is definitely a very miscalculated move by the BCI through its chairman, Mr. Manan Kumar Mishra, and it seems that this particular incident has got a history, and that history is that the remark of the Chief Justice, consequent the protest by the students on various issues at Jantar Mantar. At that point of time, this very chairman had issued a press statement, making all sort of allegations against the protesters in a very bad taste, which at that point of time also he was, cautioned. Then now, yesterday, he has jumped into a controversy where he should not have actually. The letter which has been issued in the form of a circular to all the state bar councils, who are the statutory bodies created under the Advocates Act, to stop enrolling the whole batch of the prospective lawyers, the law graduates, which is absolutely out of line, of the Bar Council functions. The Bar Council of India had no authority, no power, particularly Mr. Manan Kumar Mishra, Chairman Bar Council, had no power to issue such a circular. And within half an hour, he must have been told, and he must have realized that this is outside his jurisdiction, is outside his power. So definitely, then the course was corrected, and even the inquiry has been dropped. Of course, the citizens have got a right, fundamental right of freedom of speech. And those students of Nalsar, Hyderabad, were simply conveying were exercising that right and conveying that feeling to their authorities. Right or wrong, I'm not going into that debate. But definitely that power was there. And Mr. Mishra has absolutely, stepped out of his line and absolutely misused the office of Chairman Bar Council, and he must go. I personally feel he must go.
All right, Swati Jindal Garg, bringing you into this as well. Your thoughts, we've just had Advocate Sanjay Bansal say that it's possibly time for Mr. Mishra to perhaps give in his resignation on this entire matter. Firstly, do you feel that that would be required, or is that something that we can expect now the students to start demanding? And secondly, I just want to understand from your perspective as well. I don't think the legal fraternity is unaware in India, or that the Bar Council of India was somewhere expecting that the order that they've passed, the circular that they've notified, will be met in a welcoming manner. But at the same time, Dr. Garg, we have now seen in the recent past many such cases where people have in their personal capacity made certain comments that have not gone down well. We've had people of the medical fraternity who face that. You come online, you say something on social media, and then they've been either suspended or their licenses have been suspended for a few months. So there is a professional, we see now, impact of things that people are saying in their personal capacity. How do we then draw this line going forward in India? Because I think this is where the larger debate needs to go as well. This is not just about the Bar Council of India putting out a notice that we won't enroll people from this particular batch. Like I said, this is happening across professions. We see that people are making a lot of personal comments, so they're taking personal positions in their personal capacities as citizens of India, but there is a direct professional impact of that.
Well, Devika, first of all, to put my thoughts on record, I think it's extremely distressing. A direct autocratic display of authority and misuse of authority at its peak. A country where we are penalizing students, and I wouldn't call it penalizing, I will also put it in the line of a threat, where you are threatening to spoil a person's career by just saying he has passed a 5-year course, and now you're saying, well, oh, how dare you say this? Now I'm not going to allow you to practice. I will ban your enrollment. So you are not only attacking their freedom of speech, you're also attacking their right to choose their profession, to choose their livelihood, and it is a direct attack on their right to life, because right to livelihood is a major integral part of a person's right to life. Having said that, it was, of course, the highest impropriety by the person concerned to pass an order of this stature without, almost like I said, an authoritative gesture, misuse of his authority. Secondly, a very pertinent question that has been posed by you as to where some people who happen to be a part of a profession and they say something in their personal capacity and immediately they face the consequences in their professional life. I would like to say one thing, Devika, over here, that when you get into a profession, even though the general parlance say that, well, you should keep your personal and professional life different, I beg to differ here, because I think that you cannot keep your professional life and your personal life in two separate pigeonholes. Somewhere or the other, your personal thoughts will impose upon your professional considerations and vice versa. So if you are a person of responsibility, Let us take the example of a legal professional. A legal professional is also an officer of the court. So a legal professional cannot go around saying certain things and say, well, that I said in my personal capacity. It is only one brain that we all have, and we use the same brain to take personal decisions as well as professional decisions. So at that stage, we cannot isolate our professional life and say, well, please don't think that this is the statement coming from a lawyer. I, Dr. Swati, say this. That cannot be done. You have to be ultimately answerable and accountable for all statements that you make. It is very unfortunate that people who have undertaken a huge level of study and have gone through years of studies, then they come and join a profession, and yet they do not seem to have the sense of knowing when to say, what to say, and at what platform to say it. They are so enamored by the social media that they immediately want to put out everything on record. So there is something called diplomacy. I today say that, okay, maybe you are very narrow minded, maybe you are archaic. You go ahead and you think certain things, but how dare you say it? And how dare you say it on record in the environment that we are living today?
Yes.
This again is a very different statement from the students registering their protest. Of course, they have the right to do that. But having said that, having done that by them, at this stage, can you really suppress the voice of dissent? That is the question. And if you should have known better, well, then you have to pay the price for it.
Yes, absolutely. But at the same time, Justice A. N. Mittal, bringing you into the conversation here as well, we've really just watched the government dabble with where to draw the line as far as free speech is also concerned. Here is a batch of law students who have registered a protest against the presence of the CJI at their convocation ceremony. But we've just seen the sort of videos that have come out of a Jantar Mantar, and you've also watched a government that has come in, multiple voices of the government, and whether those multiple voices matter or not, the voice in that moment that mattered the most was the Prime Minister. He has come out on record and said that please do not take any punitive action against people who were talking the way they were at the Jantar Mantar protest, videos that have gone viral online, and it's our responsibility to show them the better path. Given that that's just happened in this country, where there has been a huge uproar and debate over what even constitutes as free speech, we have the Bar Council of India coming and inserting itself in a matter that the CJI has rightly pointed out had nothing to do with them. What example, Justice Mittal, are we then setting for the next generation, which anyway believes that there is no freedom of speech in India, that there is no right to dissent left in India?
Basically, Devgaji, it is the dictatorship of the chairman of the Bar Council of India. And I'm afraid that there is any resolution of the executive committee of the Bar Council of India. Bar Council of India acts by a resolution of the executive committee. And I think that there is no resolution of the executive committee. Secondly, I very much wonder that the chairman of the Bar Council of India do not know about the basics of the constitution and the basic of the Advocates Act 1952. This power has not been given to anybody I say. Even the Chief Justice of India cannot say. Even the Prime Minister or the President of India also cannot say not to enroll any student unless he is having some criminal background or the grounds provided under the Advocates Act. So the action of the Bar Council of India is condemnable and very much condemnable. And I am also afraid that who has made him the chairman, who doesn't know the basics of the constitution, the freedom of speech, who doesn't know the basics of the Advocates Act. He has acted totally in the garb of dictatorship, and this action cannot be sustained. Moreover, when the Chief Justice of India has already said that it is a matter between me and the students, you are nobody to come in between me and the students. If the students do not want to hear the Chief Justice of India in their convocation, okay, the students have a right. They have right to say. And the person aggrieved could be the the Chief Justice of India. But in this case, the Chief Justice of India is not taking any action. He is not aggrieved, and the action of the Chairman of the Bar Council of India to write to whole of the Bar Councils of the India not to enroll, I think this is not only unconstitutional, it is very much condemnable, and it is pure dictatorship. And in my opinion, the advocates may take the decision that whether such person should retain the post of the Chairman of the Bar Council of India, which is a very much important post under the Constitution of India and under the Advocates Act 1952. So, if there were some, for take it granted, if there were some objections against some particular students, those objections must have been brought to the notice of the Chief Justice of India, should be brought to the notice of the Executive Council of the Bar Council of India, that
Yes.
such and such person is having some criminal background, so he must not be enrolled. But you are passing a blanket order without any justification, without any jurisdiction, without any power. This is certainly very much surprising.
And that's what I feel like, is nobody keeping up with the news and what's happening in the country. Like I said, we've just had a month-long debate over freedom of speech and freedom to dissent in India. And despite all of that, we now have this sort of a controversy within the legal fraternity. Absolutely uncalled for, completely unnecessary. But before I bring in Ruchit Kamal into the conversation, some news coming in. Over 440 alumni of the National Academy of Legal Studies and Research, Nalsar, have written an open letter to the Bar Council of India Chairperson Manan Kumar Mishra against the directions that were issued by the BCI that were later withdrawn to stop the enrollment of the students of Nalsar University over protest campaign against the Chief Justice of India. The letter states that though the bar on enrollment and demand for an inquiry and report were withdrawn shortly due to public pressure, the alumni have written the letter to condemn the manner in which Mr. Mishra has approached the question of students, faculty and the autonomy of universities in India. Ruchit, your thoughts on this matter as well. What sort of a precedent do you feel we're setting? And somewhere do you feel that while we do a lot of times, Ruchit, talk about the lack of freedom of speech or the lack of dissent in our country or an inability to voice our opinions, do these sort of instances where you've had a Bar Council of India wrongly use its powers, but at the same time you've had the Chief Justice in a way come in and say that no, this is not the correct way to go about things. Does this somewhere also give, or should it give us a little bit of hope and also make us realize, Ruchit, that all is not horrible and awful in India as we keep on lamenting day and night?
Yeah. I completely agree with the points that you have mentioned, and all the other panelists. I really respect their work and their comments because they are standing up for the constitution that is upholding the rights of this, rights of the young people and rights of the people who are trying to build democracy and bring back democracy in this country. Point number one, to all the panelists, which they have been reiterating again and again, is that the representation given by the 450 students is a peaceful representation, and it does not legally regulate the Chief Justice of India or the Vice Chancellor from inviting or continuing with the convocation or from continuing from the ceremony that was actually announced. That is the very important point which should be noted down. And the second most important point is that how does BCI become a statutory authority? The statutory authority is the Government Act, is the Advocates Act that should be imposed and that should be looked at, and then a decision should be taken. But BCI does dictatorship, as mentioned by Mittalji. The office holder does dictatorship and does not consider the law that is being existing, the law that he is supposed to read and implement. They do not read the law. They do not try to implement the law. They instead try to look at how do they impress Chief Justice of India, how do they discard democracy in this country, how do they discard basic dissent of law pursuing students in this country. One thing which I want to reiterate again and again, students of this country, law students of this country, advocates of this country are there to read, understand and implement the values that Constitution of India teaches. And that Constitution of India empowers and asks every citizen, including advocates and including working class people, to equally question the state, equally question everyone. It can be Chief Justice of India, it can be President of India, it can be Prime Minister of India. If there is any dissent, if there is any disagreement, they need to submit a representation. Why does a representation impose a blanket law, impose a blanket ban on young students and very bright students? It's a national university. It's not a university of a very normal kind. It's not a state university. It's not a private. It's not a university of no importance. It's a university from which it's a university from which very progressive and very proactive alumni that university has given. And Nalsar has been as a person from Telangana, I would like to reiterate again that Nalsar has produced many people who have been proactively fighting for the rights of people, who have been actively fighting for the constitutional values implementation. So completely, one thing which I want to finally tell is that Constitution of India empowers every citizen to criticize. Constitution of India empowers and gives that legal authority for every citizen to submit a peaceful representation that we do not disagree with a decision that you took. If we are disagreeing with a decision, does a BCI who is given by an electoral position, does he disregard the Advocates Act? Is the question that I want to ask. Is this the precedent that the BCI is trying to set for the youth of this country? I'm a law student who is studying in Telangana. There are many other law students who are studying in Telangana. Is this the precedent that you are setting for the law students, that the lawmakers itself and the advocates itself and the BCI itself will not follow the law and will not follow the constitutional values? Is the question that I'm trying to ask.
Right, absolutely. On that note, I've completely run out of time, but I thank all of our guests for joining us on the broadcast to take this pertinent conversation forward. We slip into a very short break.